Thank you very much, Mr. Deputy Vice President, beg your pardon, for the opportunity to speak on this very important bill, the bill before us, entitled the Miscellaneous Provisions, Proceeds of Crime, Anti-Terrorism, Financial Intelligence Unit of Trinidad and Tobago, Securities, Insurance, Non-Profit Organizations, the Civil Asset Recovery and Management and Unexplained Wealth and Miscellaneous Provisions, FATF Compliance Bill 2024. A bill, Mr. Vice President, which amends 8 pieces of existing legislation with 10 clauses and was passed with amendments in the other place on Friday, the 15th of November, 2024. Mr. Vice President, my contribution today will serve to emphasize the pilot of the Honorable Minister of Finance, whose remarks I commend. I will today highlight key aspects of the bill to underscore the importance, and in particular, in relation to Trinidad and Tobago's obligations for implementing the Financial Action Task Force international standards. As this chamber is aware, those standards are a global benchmark for preventing, detecting, investigating, and prosecuting financial crimes, in particular, money laundering and the financing of terrorism and the proliferation of weapons of mass destruction. These 8 pieces of legislation which we seek to amend today, Mr. Vice President, include those mentioned in the very title to the bill, already named by the Honorable Minister of Finance, and I'm not going to repeat those names seriatim. Mr. President, by way of introduction, the FATF is the global AML, anti-money laundering, CFT, counter-financing terrorism, standard-setting body, which develops and promotes worldwide standards for combating money laundering and terrorist financing. I need not elaborate given the comprehensive remarks already given to this august chamber by the Honorable Minister of Finance. Complying with FATF recommendations, Mr. Vice President, is crucial for maintaining a safe, secure, and transparent international and national financial system, strengthening our economy, protecting our citizens, and contributing to global efforts to combat financial crime and terrorism. This piece of legislation in the form of the bill before the House, Mr. Vice President, is a result of an ongoing hands-on technical assistance effort between our national organizations and with assistance from international bodies such as the Global Forum on Tax Transparency, the European Union, the Organization for Economic Cooperation and Development, and the FATF. Mr. Vice President, it should be noted that in addition to adhering to the FATF obligations, the EU list of non-cooperative jurisdictions for tax purposes underscores the ongoing efforts to mitigate risks associated with jurisdictions that present significant challenges in their regulatory frameworks. By maintaining and updating such a list, the EU and its partners aim to promote transparency, accountability, and compliance with international standards, thereby protecting the integrities of their financial institutions and ensuring a safer international economic environment. And countries included in this list may lack robust anti-money laundering and counter-terrorist financing measures, posing risks not only to their own economies, but also to the global financial system. So that being in compliance with FATF Recommendation 35 serves as a critical tool to demonstrate Trinidad and Tobago's commitment against financial crime, enhancing cooperation and vigilance among nations within the international sphere. Mr. Vice President, the bill before us today will go a long way, as the Minister of Finance, the Honorable Minister of Finance has already pointed out, in ensuring that Trinidad and Tobago is compliant, and in particular, compliant with FATF Recommendation 8, non-profit organizations, FATF Recommendation 22, designated non-financial business and professional customer due diligence, Recommendation 26, regulation and supervision of financial institutions, Regulation 27, powers of supervisors, and Regulation 35, sanctions. And we are particularly concerned, as I will demonstrate shortly, with Recommendation 35 on sanctions. Mr. Vice President, as mentioned in the other House, Trinidad and Tobago is currently preparing for its 5th round mutual evaluation process by the Caribbean Financial Action Task Force, commencing in 2025, a matter of mere weeks, with an on-site visit in March 2026. And the CIFATIF Secretariat has confirmed that Trinidad and Tobago will be the first country to enter the 5th round mutual evaluation process and present its mutual evaluation report no later than the 31st of December 2026. This process, Mr. Vice President, will assess the effectiveness of Trinidad and Tobago's AML-CFT measures and evaluate its technical compliance with FATF's 40 recommendations and 11 immediate outcomes. Mr. President, I have the honor to lead a very strong Trinidad and Tobago CIFATIF team for the important 4th round 59th plenary taking place in Jamaica next week, attended by CIFATIF countries, and where we will be welcoming the United States of America to CIFATIF membership for the first time. This assessment process, Mr. Vice President, will be an extremely rigorous, more results-oriented process focusing on specific actions to tackle money laundering, terrorist financing, and the financing of weapons of mass destruction. Senator Lachmidial spoke to implementation of the legislative sweep that this composite miscellaneous provisions bill is seeking to introduce, and questioned with legitimacy the extent to which Trinidad and Tobago is building out its implementation. And I would advise this chamber, Mr. Vice President, earlier this year, my office held a workshop, an all-day workshop in St. Joseph, Maracas, where we brought together all of the regulatory agencies and bodies in Trinidad and Tobago who are concerned with the implementation of our CIFATIF and indeed our Global Forum implementation. And it was a very educational process. And one of the flags, I won't say it is a red flag, but it certainly was a red flag, that process reminded us of, and it is a reality in Trinidad and Tobago today. So this is not a criticism that can just be leveled against the government. This is a reality about our day-to-day life and our day-to-day regulation of our working experiences. That workshop highlighted for us the extent to which in Trinidad and Tobago our institutions operate in silos. And what came out of that workshop was a eureka experience by everyone to recognize the degree to which in the system that we are building out for CIFATIF's implementation of the financial regulatory system that we are subscribing to, by this bill, the legislative suite that already exists, and future legislative measures that we will be coming back to this Parliament with, the extent to which all of us have to work together and not operate in silos. And that is perhaps one of the most important lessons coming out of the work in progress that is taking place right now as we build out the implementation of our regulatory system with CIFATIF. And that rigorous, more results-oriented process, the shorter cycle, greater scrutiny, strong follow-up mechanisms will ensure that our government and our institutions stay focused on taking effective action to detect, prevent, and punish money laundering, terrorist financing, and the financing of proliferation of weapons of mass destruction. It is, Mr. Vice President, a work in progress. That is the most important part of what we are talking about now as we bring this miscellaneous provisions bill to this Parliament and as we continue to work through our preparation for the 5th round mutual evaluation. And so the passage, Mr. Vice President, of this piece of legislation is a crucial step in our preparation and demonstrates Trinidad and Tobago's commitment to complying with FATF's 40 recommendations. The crux of this bill is primarily, as I mentioned earlier, to address recommendation 35, for which Trinidad and Tobago is presently rated as partially compliant, and we are working towards becoming largely compliant. Significant threshold improvements in the tiered assessment by which FATF measures nations' compliance. According to the FATF standards, Mr. Vice President, Recommendation 35 mandates that countries should ensure that there is a range of effective, proportionate, and dissuasive sanctions, whether criminal, civil, or administrative, available to deal with natural or legal persons covered by Recommendations 6 and 8 to 23 that fail to comply with AML CFT requirements. Sanctions should be applicable not only to financial institutions, but also to their directors and senior management. Mr. Vice President, Trinidad and Tobago's technical compliance under the ongoing fourth-round process, under the previous fourth-round process, pointed to a technical deficiency in the existing legislative regime then for the availability of civil and administrative sanctions, although our criminal sanctions appear to be proportionate. The civil and administrative sanctions are not. Trinidad and Tobago was noted in the fourth-round evaluation as having a deficiency related to the lack of administrative monetary penalties for the breach of AML CFT CPF laws. So currently, the AML CFT legislation makes provision for criminal sanctions to be imposed against financial institutions and listed businesses for breaches of the AML CFT laws. Provision is also made to empower the supervisory authorities, the Central Bank of Trinidad and Tobago, the Financial Institutions Union of Trinidad and Tobago, the TTSEC, Trinidad and Tobago Securities Exchange Commission, to enforce a wide range of dissuasive and proportionate administrative penalties for breaches of AML CFT obligations, including, among others, the issuance of compliance directives for listed businesses and financial institutions, and the suspension or revocation of licenses for financial institutions. In this regard, Mr. Vice President, the criminal penalties include terms of imprisonment and monetary penalties. The terms of imprisonment are contained within the offenses created for breach of the respective regulations in Section 57(1) Proceeds of Crime Act, Section 42(1) Anti-Terrorism Act, Section 27(4) Financial Intelligence Unit of Trinidad and Tobago Act. Currently, the supervisory authorities, the supervisors, have the power to impose criminal penalties in a wide range of dissuasive and proportionate administrative penalties for breaches of the AML CFT obligations. In particular, the financial obligations regulations, the financial obligations financing of terrorism regulations, and the Financial Intelligence Unit of Trinidad and Tobago regulations, which I will compendiously refer to as the regulations. As part of the regulatory process proposed in this bill, Mr. Vice President, if the financial institutions or listed businesses fail to pay the fine and fail to remedy or discontinue the breach in compliance with the notice issued by the supervisory authority under the new proposed section, and those sections are 51C Proceeds of Crime, 42(1)B Anti-Terrorism, and Section 27(5) Financial Intelligence. And the honorable ministers have already referred us to the clauses in the bill. In the event that those financial institutions fail to pay the fine and/or remedy or discontinue the breaches, the supervisory authorities will be authorized to refer the matter of the breach committed by the financial institution or the listed business to the Commissioner of Police to consider commencing an investigation into a criminal offense created by Section 57(1) Proceeds of Crime Act, Section 42(1) Anti-Terrorism Act, and Section 27(4) Financial Intelligence Unit of Trinidad and Tobago Act. Mr. Vice President, the intention is to ensure that those financial institutions or listed businesses who fail or refuse to comply with the instructions of the supervisory authority will remain liable to the criminal penalties under the acts which I have referred to. And this is consistent with existing regulatory approach under the Financial Institutions Act, Chapter 7909, and the Insurance Act, Chapter 84, Number 1. The most recent legislative amendments which engaged the supervisory working group under NAMLAC was the introduction of an administrative fine regime for compliance with Recommendation 35. The process for legislating for this regime was initiated through the introduction of a miscellaneous provisions FATF Compliance Act 2020, which was assented to in December 18, 2020 in particular, and amended by the following pieces of legislation: the Mutual Legal Assistance in Criminal Matters Act, Chapter 11, Number 24, the Proceeds of Crime Act, Chapter 11, Number 27, the Anti-Terrorism Act, Chapter 12, Number 7, the Interception of Communications Act, Chapter 1508, the Financial Institutions Act, Unit of Trinidad and Tobago Act, I beg your pardon, Chapter 7201, the Income Tax Act, Chapter 7501, the Central Bank Act, Chapter 7902, the Financial Institutions Act, Chapter 7909, the Companies Act, Chapter 8101, the Securities Act, Chapter 8302, and the Non-Profit Organizations Act Number 7 of 2019. The Act, Mr. Vice President, made initial amendments to those substantive acts for each of the supervisory authorities to facilitate the imposition of administrative penalties against financial institutions and listed businesses for failure to comply with AML-CFT requirements. This working group, the supervisory working group, previously collaborated on an introduction of administrative monetary fines for AML-CFT CPF breaches policy paper in 2021 for the amendment of regulations to facilitate the penalties introduced in the substantive legislation. Extensive consultation took place. Extensive feedback was received from the supervised entities, financial institutions, and listed businesses on this policy, which has prompted the supervisory authorities to propose further amendments to the Proceeds of Crime Act, the Anti-Terrorism Act, the Financial Intelligence Unit, Trinidad and Tobago Act, and the regulations to provide for greater proportionality in the application of those administrative fines, as well as to ensure that aggrieved persons are able to access due process before our courts. Mr. Vice President, the supervisors do not have the power at the moment to levy monetary penalties for breaches of those regulations, the AML-CFT regulations. The bill before us is therefore intended to provide the foundation in law for all three supervisors to have the power to levy proportionate and dissuasive monetary penalties. And this is addressing the deficiencies that were identified in the fourth round evaluation process, and which we are seeking to correct and improve as we go into the fifth round. It is intended to set out the procedure for all three supervisors to follow when imposing the administrative monetary penalty, as well as sufficient access to due process before the courts by any aggrieved party. The specific regulations will be subject to a monetary penalty which will be set out in the schedules to the respective regulations, with the applicable monetary penalty for breaches of this specific regulation. In addition, Mr. Vice President, to Recommendation 35, this bill seeks to address FATF recommendations numbers 26 and 27. Recommendation number 26 states that countries should ensure that financial institutions are subject to adequate regulation and supervision and are effectively implementing the FATF recommendations. Competent authorities or financial institutions should take all necessary legal or regulatory measures to prevent criminals or their associates from holding or being the beneficial owner of a significant or controlling interest or holding a management function in a financial institution. Countries should not approve the establishment or the continued operation of shell banks. Recommendation 27 states that supervisors should have adequate powers to supervise or monitor and ensure compliance by financial institutions with requirements to combat money laundering and terrorist financing, including the authority to conduct inspections. They should be authorized to compel production of any information from financial institutions that is relevant to monitoring such compliance, and to impose sanctions in line with Recommendation 35 for failure to comply with such requirements. The supervisors must have the power to impose a range of disciplinary and financial sanctions, including the power to withdraw, restrict, or suspend the financial institution's license where applicable. Mr. Vice President, according to Recommendations 26 and 27, the FIUTT should be able to demonstrate that it has the ability to conduct off-site compliance examinations as part of a risk-based approach to AML-CFT supervision. The FIUTT Act currently does not permit such off-site compliance examinations. Clause 5D, Mr. Vice President, of this bill is intended to provide the FIUTT with the power to compel the production of books, records, documents, or other information which is relevant to assess compliance with AML-CFT laws without first commencing an actual on-site examination. And the FIUTT will also be provided with the power to compel the production of such information that is relevant to assess compliance with AML-CFT laws. And this approach is consistent with the supervisory powers of the Central Bank of Trinidad and Tobago and the Trinidad and Tobago Securities Exchange Commission for off-site supervision. So we're not creating something out of the blue. We are implementing measures that are already endowed in other regulatory institutions to ensure that we have a harmony of administrative regulations across Trinidad and Tobago. Mr. Vice President, in accordance with FATF Recommendation 22.1d, Clause 3E, Roman 3 of this bill is proposed to ensure a clear and concise understanding of the functions by lawyers, notaries, other independent legal professionals, and accountants who are covered as a listed business and are subject to AML-CFT controls in this jurisdiction. The performance of these professional functions must be consistent with the Recommendation 22 formula and alleviate any misrepresentations of the terms and the remit of those professionals in their daily operations. Making this amendment at this juncture is a preemptive measure to ensure the intention of FATF Recommendation 22 is met prior to Trinidad and Tobago's fifth round mutual evaluation. Mr. President, this bill also adheres to the outcomes of the National Risk Assessment on the non-profit organization sector, recommendations made by the World Bank and the EU Global Facility, as well as FATF Recommendation 8, which aims to protect NPOs, non-profit organizations, from terrorist financing abuse. Clause 5 of the bill amends the FIUTTA and serves to introduce a new term into that act called, and the Honorable Minister of Finance rose to assist Honorable Senator Dr. Richards with reference to the Oversight Authority. The FIUTT will perform the function of this Oversight Authority over non-profit organizations as defined in Section 41A of the Non-Profit Organization Act, using the powers outlined in the new proposed Section 80J, 18J of the FIUTT Act. Subsequently, Mr. President, Clause 8 of the bill also amends the NPO Act in order to give effect to these changes. It has been noted, Mr. Vice President, that quite often non-profit organizations or listed businesses put inaccurate or false information on their documentation as they submit to the FIUTT. In seeking to rectify this, Clause 5 of the bill was further amended in the other place to introduce a new section, Section 18K. It is now an offense for non-regulated financial institutions, listed businesses, or non-profit organizations to knowingly make a misrepresentation in the documents to the FIUTT, and they will be liable on summary conviction to a fine of $250,000 and to imprisonment for 2 years. In addition, Mr. Vice President, Clause 9 of this bill proposes to amend the Civil Asset Recovery and Management and Unexplained Wealth Act, CARMUA, C-A-R-M-U-A, the acronym, to address a concern which was raised by the judiciary in July this year during one of the several asset recovery workshops hosted jointly by the Office of the Attorney General and Ministry of Legal Affairs and Gentium UK, who were retained by the British High Commission to assist Trinidad and Tobago with strengthening its asset recovery regime. The issue identified by members of the judiciary in the collaborative working association that is ongoing in developing our FATF compliance was in respect of the disjunctive or conjunctive application of Section 31, subsection 2 of CARMUA, as it is currently silent. The provision provides for matters to be referred where a person has been acquitted of an offense relative to recoverable property, or in any other case where the Director of Public Prosecutions is of the view that the matter should be referred to the Civil Asset Agency. And one of the important parts of the Civil Asset Recovery piece of legislation that is now law in this country and has been successfully defended by my office as being fully constitutionally compliant, it's now on the way to the Privy Council, is that under that piece of legislation, you don't need to identify and convict an individual in managing corruption anymore in this country. You can identify what is known as the recoverable property and seize the recoverable property, and then those persons who are associated with that property will have to come to the courts to justify how it is with their track record of such disposable income as they're transparently able to account for, they have a financial interest in this recoverable property. And unless they can justify how they come to have such an interest in this recoverable property, the property remains seized and forfeited to the state. So that is an area in which the DPP is being given power on issues clarified by the judiciary, and the provision provides for matters to be referred where a person has been acquitted of an offense relative to recoverable property for the Director of Public Prosecutions still to refer the matter to the Civil Asset Agency. It gives me great pleasure to say that Cabinet has approved the creation and operationalization of the Civil Asset Agency, and it is expected, Mr. Vice President, that that agency will be fully functional during the first quarter of 2025. In the other place, Mr. Vice President, this bill underwent additional minor amendments which simply corrected typographical errors which were raised during the committee stage. As I conclude, Mr. Vice President, I would like to applaud the hard work and diligence over the past years from 3 competent authorities of the Supervisory Working Group: the Financial Intelligence Unit of Trinidad and Tobago, Mr. Nigel Stoddard, Director, Ms. Mary Campbell, Deputy Director, Mr. Kevin Radix, Director, Compliance and Outreach, Mrs. Kayleen Dowden, Director, Legal Services, Ms. Shivana Sharma, Legal Counsel 2, the Central Bank of Trinidad and Tobago, Ms. Nadira Ramatula, Manager, AML Unit, Financial Institutions Supervision Department, and Ms. Sabrina Lee John, Assistant Manager Legal, and the Trinidad and Tobago Securities and Exchange Commission, Ms. Rosalind King, Director, Compliance and Inspections, Ms. Leslie Ann Brown, Lead Counsel Advisory, and Ms. Keisha Celestin, Senior Legal Counsel, under the leadership of Ms. Viana Sharma, Director of the Anti-Terrorism Unit, and Chairman Namlak, for their work, ably supported by the Legislative Drafting Department of the Attorney General's Office, Ms. Ida Eversley, Senior Counsel, Deputy Chief Parliamentary Counsel, Ms. Lorraine John, Deputy Chief Parliamentary Counsel Acting, and Mr. Anil Joseph of the Chief Parliamentary Counsel's Department. Mr. President, in conclusion, I would again like to underscore the importance of Trinidad and Tobago's preparation for the 5th round mutual evaluation process. We are undertaking on a daily basis the improvement of the systems and processes that are being worked through for the implementation of the legislative regime which we have so far passed, which we are before this chamber asking this chamber to pass. And it is imperative, Mr. Vice President, that this bill is passed today. This legislation will not only strengthen this country's financial system, it will promote global cooperation, protect the economy from the negative effects of financial crime, help avoid sanctions and reputational damage, and strengthen national and global security, and will ensure that Trinidad and Tobago complies with its international obligations. I look forward to being able to announce next week in Jamaica at the 59th plenary session of CFATF that Trinidad and Tobago has passed this bill into law, and we are well on our way. And with that, I thank you, Mr. Vice President.